Welcome today to another session of ESG Committee's YouTube show. I don't know if we have, oh yeah, we have a name. It's called ESG in Law. So we'd like to talk about areas where responsible business conduct interacts with the law. We've got a great guest for us today. We have Charity Ryerson, and I'll let her introduce herself a little bit and tell you a little bit about the great work she's been doing.
Great, thanks, Patrick. Again, my name is Charity Ryerson. I'm the executive director at Corporate Accountability Lab. We're a small Chicago-based nonprofit. I started the organization about 7 years ago after having been an Alien Tort Statute litigator, also doing some torture statute litigation, a little state law, and really finding that a lot of the litigation that was happening was not getting remedy to victims of egregious human rights abuse in global supply chains, in part because of the Supreme Court really narrowing the statutes that we were using. So I founded the organization to try to diversify the strategies available to human rights advocates and victims of corporate abuse around the world. So we do use some human rights statutes, but we also use contract law and intellectual property law and international trade law to try to repurpose areas of commercial law for human rights ends.
Okay, well that sounds very interesting. So how do you use contract law or intellectual property law in some of your strategic litigation?
Yeah, so for example, for contract law, we've developed a variety of different provisions that you can put into supply chain contracts that actually give workers direct access to remedy. So if you look back 20 some odd years to the anti-sweatshop movement and think about when all of these big exposés were coming out in the late 90s and early aughts, talking about how big apparel companies primarily were engaging in various abuses in their supply chains at factories where workers were not being respected. And at that time, a lot of these companies passed these supply chain codes of conduct, which later were put into their contracts. So this idea of using supply chain contracts to protect the rights of workers overseas producing for the US market is an old idea, but it didn't work in the way that they did it. And so what we've done is we've developed a bunch of contract terms that different companies can use and embed in their contracts that say that workers who experience a violation of their rights, and particularly a violation of the supplier code of conduct, have a direct legal right to sue as third-party beneficiaries of that contract. So where they don't otherwise have jurisdiction to be able to bring a claim, or it's too difficult or burdensome, now they have the ability to do it through a relatively comparatively cheap and easy process of a contract violation claim in state court in the United States. So right now, the city of San Francisco is experimenting, is our sort of second pilot with this language, and they are in the process of putting it into apparel contracts for all of the city's apparel purchases. So from there, we'll go on to more private contracts that don't include government procurement. So that's one example of how we would use commercial law. So normal law that if a company as a repeat player in the system wants to go after a certain type of statute that might be disadvantageous to them in some way, that's going to be a human rights statute. They need contract law for a lot of reasons. So they wouldn't go after it structurally. And so it's something that is a strategy that, if it works, is then somewhat protected and has some longevity in a way that human rights statutes have not.
That makes sense. So I've been involved with the ABA's Model Contract Clause project for a number of years as well, which is very similar. And we have a provision that allows for third-party beneficiary rights that companies can implement or not implement, just depending on where, and you can broaden or narrow the scope of the rights that you're going to afford them as well. But it's definitely incredibly important. And even if they don't have access to remedy themselves, at least contracts that allow for operational level grievance mechanisms and other kinds of reporting mechanisms, so that at least workers have some type of a voice, is incredibly important.
I think that's right. The ABA's model contracting clause project started in one place. I think it's evolved really significantly.
Yeah.
And now, since it's focused more on the idea of principled purchasing, it's
Yeah.
really a different animal than it was when it first started. So back when it first started, that third-party beneficiary language that's in the footnote there,
Yeah.
that's something that we provided to them. So that's our language that we were piloting and using. But it only got footnoted because there was a question about whether it was commercially viable, which I
Yeah.
think is really interesting, because now where you see where the project is, it's much more aspirational in terms of trying to change the very business model that is incentivizing these types of abuses. So if big lead companies, brands that well-known brands, are pushing prices down, and then each step of the supply chain, each actor is pushing
Yeah.
prices down, eventually at the other end of the supply chain, the local factory, for example, can't actually afford to produce the good at the price with the quality standards and also comply with the labor code. And so I think the principal purchasing model says these companies, these big brands, they should also be accountable for the ways in which their purchasing practices drive abuse. So I think that is an excellent model, but I think it also raises questions about commercial viability. So our more limited testing of the third-party beneficiary language, is kind of testing the commercial viability of that kind of model, whereas something that goes at the supply chain more structurally, I think in some ways is much more important, and also much harder, I think, to put into practice in the real world. So both of them are really important.
Yeah, when I talk to companies or other stakeholders about the commercial viability of issues like, for instance, reasonable pricing clauses, I always just use the analogy. If your supplier came back to you and said, we can supply you this spinach, but it's going to be very difficult. In fact, it's going to be likely that it'll be laced with E. coli, you would think, okay, well, I guess I'm going to have to pay a higher price, and there wouldn't be an issue about it. It's not a question of commercial viability. It's a question of, viability. Can you put out a product that's not tainted? And so the question is, do we agree that products that are produced by forced labor, human labor, are so sufficiently tainted that they don't belong in the stream of commerce? And I think most, you and I of course agree. I think most consumers agree as well. And it's a part of the project is to allow for consumers to avoid tainted products like that. Can you tell me a little bit before we move on? I'd love to talk a little bit about how you use intellectual property to, protect worker rights.
Yeah, so we have developed, again, quite a few now licenses that put human rights and environmental conditions, sometimes very specific, sometimes broader. It's kind of a la carte model, somewhat like the model contract clauses, where software developers can embed these kind of terms into their licensing contracts for software that they're developing. We've done that along with a group of software developers who now have spun off into their own organization called the Organization for Ethical Source, OES. So OES is maybe 200, 250 software developers that are using these kinds of terms in their intellectual property. I think long term, it would be great to imagine a world in which someone develops an essential medicine, right? A pharmaceutical that is really important, and they wanted to make sure that it wasn't going to be sold at jacked up prices in Africa, which is sort of a historical problem that I think we've all seen and is needed to be regulated. Is there a way that they could embed certain human rights norms into that IP so that the pharmaceutical that was being created would be ensured that it wouldn't be used in an unethical way? Or think about, development of the atom bomb. Like there's a lot of different pieces of IP that go into outcomes that are very problematic, but what if the scientists and the thinkers were able to constrain the use long-term by embedding it at the outset? I think that there's some practical logistical barriers to this, but if we want to find a way to embed values in our global economy, then we need to start finding ways to make it in binding legal instruments, which would include patents and licenses and contracts.
Well, on the topic of licenses, there are plenty of, toy companies that license out their IP to third parties, and that's particularly an egregious area where there's a lot of forced labor, human labor, and other problematic worker issues in those toy supply chains. Have you ever been involved in any projects where it was a company that was licensing their IP to third parties and implementing certain model contract clauses to ensure worker rights? Because I've done it myself, but I'd love to hear your thoughts as well.
I think the most robust model of that is what's being done by the Workers' Rights Consortium in the university market. So they're using university licensing agreements. So when you get like a UCLA sweatshirt or whatever, that's IP that belongs to the university. So when they license that IP in order to produce those sweatshirts, they have put, pursuant to WRC, Worker Rights Consortium agreements, these kinds of terms in. Now, whether or not it's working perfectly in the university market, I wouldn't say that it's working perfectly, but it is kind of a vast experiment. Now, I think the real question is, can you transition from something like public procurement or a university market into mainstream private contracting and licensing? there's less leverage. And so I think that the one big insight that we have drawn from working in this licensing and contracting space and looking at what the WRC is doing, looking at what Electronics Watch is doing, they do some of this in Europe where there's a lot of government procurement of computers and other electronics that embed these kinds of terms, both in licenses and in other forms of contracts. Is trying to just figure out, is what's driving compliance actually the legal contract, or is it the existence of external pressure? Whether that is, political pressure, if it's a public procurement issue because voters care. Is it in the university market, student activism? Students care, and so they're going to protest and make it a problem for the university if they're producing in sweatshop-like conditions. So I think that it's really a combination. And insofar as lawyers like us look at this and say, all we need to do is change the contracts and then there will be compliance, I think that the reality has not really borne that out. It's been the case that these are contracts and licenses are really supportive of broader social movement goals or political activism, et cetera. And absent those other sources of pressure, the contracts standing alone don't make that big of a difference.
Yeah, no, I find that oftentimes part of the process of implementing really strong contracts is conveying to the other side that this is not just status quo, sign our code of conduct and we're going to be done with this, that this is actually enforceable language. And part of that comes from conveying to the supplier that the buyer is in a world now where they're regulated by a lot of other different entities and they're having their feet held to the fire for a number of different reasons, such that they actually really do want these these terms to be enforced and implemented properly.
Yeah.
And so let's talk about some of the work that your organization is doing to hold these organizations' feet to the fire, as it were. Maybe you can tell us a little bit about some of the cases you've been working on, or obviously you can't tell us anything that's privileged, but anything that you'd like to discuss, I'd love to hear more. We were talking beforehand that you're doing some work in the context of forced labor issues and some work in the context of indigenous rights issues. And I'd love to talk to you about how some of those issues are similar yet different.
Yeah. So I think that there's both kind of legal conversation in terms of framing it around cases, but there's also a conversation in terms of framing it around communities. So the way that we have evolved to practice is that we have relationships with workers, farmers, indigenous communities, et cetera, in certain geographies around the globe. And then we try to develop legal strategies that are kind of wraparound. So it might be litigation in federal court, it might be litigation, it might be a state court or local court litigation. It might be a petition to the FTC. It might be an FCPA complaint if there's a corruption related issue in the human rights issue. It might be working with Customs and Border Protection on implementation of Section 307, which prohibits the importation of forced labor produced goods. It might be working with European colleagues on filing cases there because one of the relevant corporate actors is a European company. So I think that, the way that we structure it, like when we think of cases, yes, we do have some legal cases in the courts, and we have certainly lots of pending petitions and different regulatory agencies that we're engaged with. But we kind of think about it as a constellation around a particular community relationship and a set of needs. And so then the types of initiatives that we engage in for each community vary a lot. So it's interesting because I think in that way, we're a little different from most law firms or legal practices in that we don't specialize in certain laws. We specialize in developing the broadest range of options for a community and then determining whether or not those options are going to serve the broader agenda of that community. There's a lot of challenges to doing it this way because we do need that community to, in an ideal world, speak with some sort of collective democratic voice. So for us, the best case scenario is a really representative, legitimate, independent union or a really well-organized indigenous community. These are our gold standard communities that we work with because we can consult with them easily. And that way we can really comply with our legal ethics, right? I worked on a lot of cases in the past where we would have 1,000, 2,000 plaintiffs who didn't know each other, didn't work together. And we need to make sure that our case and our case strategy, that we consulted with the plaintiffs and that it was aligned with their agenda. With 2,000 different people with different agendas, it's actually about impossible to do. And that's a real struggle, I think, with strategic litigation, in that there's some tensions between filing these kinds of cases and really upholding our legal ethics as lawyers and also just our morals and values as advocates. And so we're trying to do this a little bit differently. So we have a lot of different cases. So we could go in different directions here.
Okay, and just to sit on that for a second, so yeah, I would imagine that yeah, you'd have to work with either a local union or perhaps an NGO, a local NGO that's focused on these issues. But yeah, exactly, that can be an intermediary to kind of coalesce the voices for you to
Right.
represent. Before we get into this, I did want to learn a little bit. How did your career take you to this point? I'd love to hear a little bit more about what was Charity doing before this, or what
Little
led up to
charity.
this.
What was little charity doing? Yeah.
What was Little Charity doing? Yeah.
So I got started to get involved in activism when I was in high school. So it was really like a childhood passion, even for me. So I was involved in a lot of work around militarization in Latin America. In college, I was super active in the student anti-sweatshop movement, which back then this was the height, between like 99 and 2003 or so. This was like the real when student anti-sweatshop movement was really making a big difference and being very effective. So I got to sort of participate in the first big wins against Nike. And that taught me a lot about the way that global supply chains work. Around this time, I also did civil disobedience at the School of the Americas in Fort Benning, Georgia, which is a training camp for Latin American militaries. Got arrested, ended up serving 6 months in federal prison for that. And while I was in federal prison, I worked sort of adjacent to the Unicor factory, which produced cages for immigrants, which was a very strange thing. But so I separated scrap metal for 12 cents an hour within the prison. And so when I think about now how my career has sort of landed in this place where I do a lot of work around forced labor,
Yeah.
in the federal prison system in the United States, it's not that it's not forced labor, it's that there's an exception to the 13th Amendment that allows for forced labor in prisons as a penalty for a crime. So I got a little taste of being a forced laborer. If I had chosen not to work, I would have been sent to county jail. Like there would have been serious consequences to that. So I did that for 6 months. Then I came out and I worked for a little, and I finished college and I worked for a little international labor rights organization here in Chicago that focused on the Americas. And there I got to work with a lot of unions that were organizing mostly on farms in Latin America. We did a lot in Colombia, Honduras, and Guatemala. So I was kind of the main program person in the field, working with flower worker unions outside of Bogota or banana worker unions in Honduras. I did a lot of anti-union violence investigations. So it was really like we used consumer campaigning, we used trade law leverage. So looking at different trade agreements that were moving through Congress. What did their labor chapters look like? Were they going to be strong enough? And if they weren't, then we would campaign against the agreement to see if we could get a stronger labor provision. I eventually got a little demoralized doing this work because we were working on a lot of campaigns, but the one that really kind of broke me, we had one where we were working with the flower workers outside of Bogota in this ring around Bogota, Colombia called the Sabana de Bogota. And these were cut flower workers, mostly women, that were cutting flowers for Dole Food Company that were being imported to the US, not labeled, because think about when you go to the grocery and you buy cut flowers. What brand are they? Who even knows, right? So we're working on this campaign, and all we really wanted was for them to comply with the terms of the instructions on the side of the pesticide containers. So these big barrels of pesticides, and it said, you can spray this, but inside of the tents in which the women work, you need to have nobody in there for 24 hours after you spray. So the reality was they just sprayed and the women were there the whole time. The community had really widespread miscarriages, congenital malformations. There were so many children that were severely disabled, and these women were earning poverty wages and not really able to adequately care for these children that had special needs because of the kind of work they were doing. It was a really rough situation, and the demand was so basic, like just follow the instructions on the side of the
Just wait a day. Just wait a day. Yeah.
basic. And we did not win that campaign. We like fought and fought. I feel like we worked so hard, and we did a reasonably good job. And it just really brought home to me that the old model where consumers can boycott and write letters and, sort of contact the company and tell them what they think, or show up with letters to the managers of the stores that are selling the goods. This was a model that kind of worked a little bit in the 90s for certain campaigns. I think that with the onset of the internet, et cetera, it all just kind of is in a wash of this overload of information, and consumer activism like that was just not working. And so I went to law school really to think, okay, how can we make it so that for companies, it is potentially going to be expensive? They're going to have to think about this as a line item. If I choose to violate human rights in this way, what is the long-term expenditure that I need to anticipate and put in the books? I don't want this to be a conversation with their sustainability department, which is a subset of their public relations department. I want this to be a conversation with supply chain logistics and general counsel and finance, because it hits them where it matters. And the only way to really do that is litigation. And that's why I went to law school.
Well, and the idea with the consumer approach was that, well, yes, it will hit their bottom line so that it will catch their attention. But the question is, who's the enforcement mechanism, right? If it's just consumers who might boycott someday, the risk of loss is quite narrow. But if it's somebody like you who's been really forceful about this, who's going to be advocating on behalf for change at the FTC or at the SEC or wherever, at government regulators, if you're working in conjunction with them, that's a lot stronger of a risk. And I know from advising companies, I can often say that, like, look, this is a very much a reality that it wasn't for you 5 and 10 years ago. And I can appreciate that you have a previous kind of conception of what this risk matrix was, but you really need to live in 2023, not 2010.
Yeah. No, I think that's exactly right. Well, and if you look at all that consumer campaigning that at the time was viewed as successful, what it really generated was the most massive greenwashing. Now, if you 20 years ago went to any company's website, it wasn't like they were covered with pictures of happy farmers. You didn't walk into a Starbucks and see it, it was all about like how much farmers love growing Starbucks coffee beans, right? But now when you go to these websites and you walk into these stores, this sort of corporate social responsibility posturing is everywhere. We are awash in it. And I think that that's really a response to these consumer campaigns that were somewhat effective. It's unfortunate that it didn't result in really effective mechanisms to improve supply chain accountability. And I think there are some marginal ways in which it did, but it largely didn't. It really resulted in this massive corporate greenwashing that we're now swimming in, and really unable to distinguish between companies in terms of their sustainability because their representations are so misleading and confusing. And so we're just sort of swimming in all of this nonsense and can't tell what's real. So in that context, consumer campaigning is almost impossible to be. It's just not effective.
But I think it's important because the one argument that you won through those first kind of 15, 20 years is that consumers do care. Consumers do care about this. Society as a whole does care about this. And laws in general are ways that society manifests its values. And so now we have a clear understanding that one of society's values is that we don't want to be buying products that are tainted by forced labor or things like this. So now that's a question of how do we as lawyers, as regulators, as advisors and advocates build a system that gives life to that consumer demand.
Yeah, this is a great question. So I think that there are a lot of different answers and they need to be happening in concert. So certainly we need litigation on behalf of victims that were harmed to get them direct remedy. I think this is something that when we think about strategic litigation, we often focus on how are we going to get remedy for victims. Initially in my legal career, I saw remedy for victims as the gold standard, right? This is what we want. If we can also deter bad behavior, et cetera, this is great. I still think that it is really, really important, right? If someone is harmed, they should be made whole to the extent that's possible under the circumstances. So that type of direct representation of victims is essential. However, it doesn't cost companies enough to prevent them or to cause them to fundamentally change their business model to do things dramatically differently in their operations around the world, particularly for a huge company that has operations in 50 countries. One issue that happens in one country, and then you represent like 25 plaintiffs who were harmed, the amount that they're going to pay out for the litigation, the settlement, all of it, if that ever even happens, is pretty marginal and doesn't seem to be enough to really change that behavior. So I think that this type of litigation is something that we do and we think is important. We also think it's important to address the false things that companies say about what they do, partially because of consumers, but also because of regulators. Companies really effectively buffer themselves from regulation by their very sophisticated false representations about sustainability. So all this sustainability noise is part of the reason that companies are less regulated than they should be. And I think to your point, about how consumers are, if you do surveys, you see that consumers do really care about this stuff. But if you look at how consumers purchase, it looks like they don't really care about this stuff.
Mm.
And I think it's because they want it, but they also know that they're fundamentally disempowered in this economy. And there's no way, no one has clean hands in this economy. It's just not a thing. So what we really need is for that to translate into regulation. So we haven't seen that for most types of harm. So that means that if a company hires a local armed group to arrest and execute or torture the union leader, there's not a regulation that really speaks to that. But the only regulation that I would say right now in the US is kind of working is on forced labor. So there, where you've got Section 307 of the Tariff Act of 1930, that is something where there has been some real progress, although it's patchy and difficult, but I think that it's the US sort of stands out from the rest of the world there. When you look at criminal prosecution of companies for these types of supply chain abuses, there are some statutes that would allow for criminal prosecution, but there has been very little. For example, under the trafficking statute, the TVPRA, there are civil and criminal provisions. There have been many, many, many civil cases under the trafficking statute. But if you look at criminal cases under the trafficking statute against corporations, there actually has never been one. So
Really?
there might be investigations going on right now. There's information suggesting that there are maybe several investigations going on right now, and that DOJ does intend to use those provisions against corporations, but it hasn't happened yet. I think there's a lot of reasons for that. I think it's very difficult to bring a criminal prosecution against a corporation for trafficking. But in terms of what's government doing, like outside of what folks advocates are doing with our civil litigation, our consumer protection litigation, et cetera, government, it's slower. It's a little bit more burdensome for them to use their tools. But I think that we're really hoping to see a significant uptick in criminal prosecutions of companies for this kind of behavior, in addition to the regulation we're seeing of forced labor produced goods.
Yeah, there's so many points I want to make. So one point was I was actually recently on a panel actually for California Lawyers Association where I sat with a prosecutor in the San Diego prosecutor's office who was prosecuting companies for forced labor violations. He didn't use the TVPRA as such, but he effectively likened it to wage and hour claim on steroids that he was basically raising, and he was saying that in San Diego, they have a department that's tasked with dealing with forced labor and trafficking issues, and he works with other colleagues in San Francisco and a few other major cities in California. And so you're getting some local enforcement of these issues. One question I wanted to ask, do you think that it's the largest companies that are involved in these problems, or is it often kind of the middle tier companies, the small to medium sized companies that are less buttoned up and more able to kind of get away with some of these crazy abuses that you're describing?
Yeah, I think that's a really good question. And I would say it really is both. In our experience, so we do a lot of forced labor investigations all over the world in a lot of different geographies and a lot of different industries. And in those investigations, what we often find is the company that is most obviously directly linked is a company you've never heard of. It's an SME, small, medium sized enterprise. However, a lot of these companies are selling to these much bigger recognizable brand names.
Yeah.
For example, we are doing some work in a seafood sector where none of the companies that we're identifying that are the producers of this particular product are names that any of us would recognize, and yet these goods are being served by Red Lobster. It's being purchased by Walmart. So you have these big brand name retailers and restaurateurs that are selling these goods, but when you look at like a company like Nike that got hit so hard by the anti-sweatshop movement, they're really interesting. I think this is probably somewhat representative. If you go on Nike's sustainability websites, there's one way in which Nike has gone a little above and beyond a lot of the rest of the industry, in that they're providing supply chain transparency to a certain extent on their website. Maps where you can go and hover your cursor over a particular factory, see where it's located, how many male and female workers. There's a lot of data there. What it doesn't do is go the next step down. Right. So you actually, and that's where you see most of the problems. So at the assembly point for a manufactured product, there certainly is forced labor in those supply chains at that point. But if you go further. So the closer you get kind of to raw materials is usually where you see a lot more of the forced labor. And so whether or not those raw materials are coming into an SME, they usually are coming into an SME, but then where do they go from there? I think that there's a lot that are coming direct to consumer, but there's also a lot that are going to these big brand name companies.
So it's a question. So one kind of question I have for you is, do you have thoughts on the kind of European approach or more the international approach, which is evolving around human rights due diligence and requiring companies to implement human rights due diligence, which peers down through the layers of their supply chain, versus maybe the US approach, which is more of a strict liability approach, which basically says we're going to prohibit you from importing goods that have this taint, and you come up with a system to address that. I guess the drawback is CBP can only detain so many shipments at a certain period of time, so the risk is relatively lower. But maybe you can discuss how you view those.
I mean, Patrick, that's exactly right. I think that the import ban strict liability model is superior, except for in the administration. That's exactly the issue, is that, when the Uyghur Forced Labor Prevention Act was passed, it really took up all the oxygen in the room at the Forced Labor Division at CBP, which is also tasked with implementing the import ban on forced labor produced goods more broadly. So if we're submitting petitions documenting forced labor in West African cocoa and many other industries around the world, when are they going to have time to work on that? And the answer is, since that legislation was passed, not clear. They haven't issued a withhold release order in a year. So they really are more than a year. And the last one was a case that we work on in Dominican sugar, but they haven't moved since then. So then a lot of people here in the US are thinking, well, gosh, this import ban works so well, let's expand it. There's a new act that's been proposed, or at least is under discussion, called the Forest Act, which is looking at blocking the importation of goods, I think it's 5 specific commodities grown on land that was really deforested, right? So this kind of thing, if it's still the same group of people, the same individuals, maybe with a little more funding, but still basically the same people who are tasked with enforcing that, I think the Forest Act would make it so that even the UFLPA might not be enforceable anymore. So there's a question of, even though I do think a strict liability model is the only way to go for some types of harms, because you cannot show that a company knew or should have known or had purpose intent or knowledge intent, whatever the standard might be, for these outcomes to take place, because that's information that's in the custody and control of the company. And even through discovery, it's all going to be privileged. So it's just, from an evidentiary burden perspective, it's so hard to get the information to show the intent of a company, that a strict liability regime that says, look, if it's there, the good is tainted, therefore, if you find it and you just don't import it, that forces a company to do its due diligence, right? That flips the burden so that the company says, well, if I don't do my due diligence, my goods might not come in. And suddenly they create the time and budget for it. Now, the European model, like the Corporate Sustainability Due Diligence Directive, the CSDDD.
That really flew out of your mouth. That's good.
I just came back from the UN forum in Geneva. So
okay,
at the CSDDD now. So I think that just having, made significant progress in the last, 2 weeks, is an exciting development. I think it is a win. And in the text, there was a lot of concern about this model as a whole being sort of generating a lot of compliance, box ticking, blah, 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 without actually creating the impact that they seek to create. I think it's kind of too early to assess. I know everybody has really big opinions on this. I actually would like to see it in practice for a while. If you look at the French mandatory human rights due diligence model, the duty of vigilance law, I think there was a lot of hope for it, but if you look at the cases that have been filed under it, it's been hard. It's not been a slam dunk so far. There are good questions about whether or not, if you put aside the litigation, if the impacts of it otherwise have significantly improved corporate behavior in ways that are more difficult to measure. That's very possible. So I don't know, but I think that the CSDDD model has a lot of I think some of the best things about it is that it's going to hit everybody. It's going to create obligations that it's not like they can just sit and sort of pray that they're not going to get caught like they would under Section 307. So I think that's a benefit. Certainly, it is highly disruptive to companies and is going to make them rethink their business model. I think that's important. I'm concerned that the adaptations that companies make will ultimately reduce its effectiveness pretty dramatically if they find ways to have sort of narrow compliance. But a lot of people in our field talk a lot about the FCPA in a way as like
I was gonna go right there next. Please,
yeah.
just
Well,
for our audience's benefit, please just give a 30-second just summary of what the FCPA is. And okay, please go.
Yeah, so the Foreign Corrupt Practices Act is some kind of powerful federal legislation that was created to stop bribery around the world. And it's been sort of effective. If you look at the FCPA prosecution that has happened by the Department of Justice, they've really, shifted some resources from companies. Now it doesn't exactly remedy the harm, but I think that as a deterrent, and if you look within corporate compliance departments, and if you look at law firms, there's this vast infrastructure for FCPA compliance where companies really have to think, is this a grease payment? If you're working overseas and you're working with foreign officials and they're asking you for money, there's a lot of regulation there that I think corporate employees are thoroughly trained on now and have a lot of information on. So at least if they're violating the law, they know that they're doing it. So that kind of regime.
Well, just to pause you for a second, getting back to the enforcer, one of the key things about the FCPA is I think in the late 80s, early 90s, some really bright, crafty DOJ lawyers decided they could really enforce this law and really make a name for themselves and really come up with a lot of strong fees. And so that created a tendency whereby there was robust enforcement from the DOJ and became a virtuous cycle. And then companies responded and law firms responded by creating these systems. So much to the point that now, you'll be involved. I've been involved in cases where, a small company gets bought by a bigger company. The bigger company comes in, looks at what's under the hood and realizes that there's FCPA issues, and they'll deliver a dossier to the DOJ saying, we've discovered this. Please, can you not prosecute us? And in exchange for this, so you have these really robust, you have the robust enforcement, so you have the robust compliance. And I've talked to individuals at human rights departments in large companies, and they've said, we've got 5 to 10 people in our department, and the FCPA folks have 1,000, doing this work. If you ask me, could I trace down up through my supply chain? If I have those resources, surely I could. So if it's a question of giving people at the companies the resources, making boards of directors cognizant of these issues, that's why people have thought of the FCPA as a type of model that you could do. So if you could just prohibit products produced using forced labor and then pass a law which allows the DOJ or other enforcers to prosecute for violations. So sorry, I didn't mean to cut you off, but wanted to give just a little bit more of that background.
Yeah, that's really good context. So there is actually some draft legislation called the FCPA for Human Rights. I don't know if this has come across your desk.
Yeah.
Yeah, so that kind of tries to use this model. I don't know if that particular piece of draft legislation is going to move. It's a good question, but it does sort of philosophically, it raises some good questions about, if you really zoom out with the idea of how do we get to the point where there is effective regulation? Is it a CSDDD mandatory human rights due diligence model? Is it something that is more FCPA compliance type model? Is it something that is more issue based, like a strict import ban based on specific issues or types of products? All of these things are kind of being experimented with. And I think in some ways, we're still pretty early days. We're definitely early days on mandatory human rights due diligence. I think we are, even though Section 307 has existed since 1930, it wasn't really being enforced until 2020 for a number of reasons.
Yeah.
The consumptive demand loophole.
The consumptive demand clause, yeah.
So that's still really early days. The Forced Labor Division is still kind of figuring it out. The Uyghur Forced Labor Prevention Act, which is much like 307, but it creates like a rebuttable presumption that if goods were produced in the Xinjiang region in China, that they were produced by forced labor. That is a very similar but slightly different model. So I think it's interesting that there are all of these developments happening right now. And when you think about what are really law firms going to do? to support companies, because this is more than companies can do internally, even pretty big ones. So there's going to be lots of development in law firms. So what lawyers in firms decide to do, how they decide to advise their clients and develop compliance regimes to deal with all of these different laws that I think sometimes will be in tension with one another. I think that's kind of where the action's at. It's going to be very interesting to see how that develops. If that develops in a positive, sort of rights respecting way, then you could have huge shifts over the next decade in a lot of different areas that touch on business and human rights. If it develops in more of a very narrow compliance, how do I just avoid legal liability, you know, in the cheapest possible way. If that's what law firms are advising their clients, then I think we're just going to be back at it, finding new solutions and new strategies and new models again in the next 5 to 10 years. So it's hard to say.
Yeah, I mean, there's always the possibility that it's just a whack-a-mole issue. Another thing you can think about too is, you know, there's business and human rights lawyers, there's FCPA lawyers. There aren't that many lawyers that have this, and part of the reason for the existence of this show is that there aren't that many lawyers that have a understanding of so many of the different responsible business conduct laws and how they relate to each other. So for instance, there's the due diligence laws and then the strict liability laws. And if you have due diligence and strict liability, it can actually be in tension with each other because you're almost incentivized to not discover issues when they arise. So dealing with that. Another issue is you have greenwashing laws, which require you to effectively procure data or secure data that you can use to validate your marketing materials. But then you also have disclosure laws. So you have to disclose a lot of that data that you're using to validate. And then you have the human rights laws. So you have the congruence of all these different laws. And so that's why I think it's becoming harder and harder for the lawyers who would hope to help their clients to avoid the spirit of the law. It's becoming harder for them to do their job, as it were.
Yeah. I think that's right. And I think that if lawyers really get involved with communities on the ground that are producing the goods that are coming to the US market and being sold by the companies that they represent, I think it will really flip. Because another thing that is kind of an emerging norm, although not yet written anywhere, but I think is sort of an expectation that is emerging, that a lot of the big companies are aware of this and smaller ones are not, is the idea that community consultation is no longer sufficient. So checking in with your factory workers in some very superficial way through a social auditor, and then later discovering, oh, whoops, we missed really important things. That's not really flying anymore. And so now the idea of how do you have real worker and community involvement in your operations in which they have some power, like some real power shifting. That's kind of the gold standard that we're working toward. I think it's going to be a while. I don't think that a lot of companies want to give up power to the workers and communities that are impacted by their operations. But that actually, if you think about it, would be the best buffer from liability. If you were working with the community that lived next to the mine and they were engaged in conversations with you, you would have eyes and ears on the ground and you would know exactly what is happening. And then that's going to give you really advanced notice. If you do this sort of long attenuated buyer supply chain model, you have no idea what's happening until way too late. And then you might be liable for it. And it might hit you hard in public relations, in your legal department. It might cost you a lot of money. And so if you could move, if really proactive, forward-thinking companies could start moving more toward an active engagement model in which the people most affected actually have a seat at the table in a sustained way, that's going to help them just kind of jump over all of the chaos in the middle of all of these competing regulations, et cetera. So hopefully companies at some point realize that. I don't think that many have yet, but you do see a few kind of experimental models or pilot projects where companies are engaging more actively with the communities that are impacted by their operations.
Yeah, and I would imagine that it's incredibly important to have trusted intermediaries, so nonprofits that are on the ground, probably religious organizations on the ground, union organizations on the ground, entities that can at least have some semblance of neutrality as between the stakeholders and the company. And also, you know, one thing I often advise is you should have a local NGO describe the codes of conduct that when they're informing the workers, they should be the ones doing the education of the workers so the workers know their rights. And they should also be the ones who are going to be reported to what if there is actually a grievance, because they're some of the only people that the stakeholders have like confidence in, that they'll be able to address their concerns and that they'll actually deal with their concerns. And so you can use it, hopefully you have some type of a local intermediary that can do the education and be receptive to complaints. That's probably a gold standard.
Yeah, I think that's right. This kind of operational level grievance mechanism development in the last, I don't know, maybe 15 years, I think has been positive. Of course, anytime you have sort of a good model of a way to do a thing, there's going to be a lesser model that is then
Yep.
created that looks like it's doing the thing, but it's not doing the thing.
Yep.
So I think that's happening a lot with grievance mechanisms, but ultimately, if you think about it if you look at like industrial relations going back to time immemorial, workers who have the ability through their union to file grievances, this has been like a model of industrial relations that's tried and true. Now, because there is such suppression of unions and union busting and, including governments that are really anti-union in a lot of the countries of production of the goods that are producing for countries like the United States and for the EU, sort of the largest consumer markets in the world, you don't always have a union. And so in some ways, the grievance mechanism model provides a sort of recourse and a way for workers to have a voice and for low-level grievances to be resolved on an ongoing basis instead of waiting until they snowball into something that is huge and really damaging for the company. So I think it's a positive development so long as it's done well. But I think that's a piece of this conversation about worker engagement as opposed to these like limited consultations.
And here's one. This is outside of really my expertise and perhaps yours as well. But I wonder if you've ever looked into this. I've been trying to. I was listening to some debate show, and they were talking about forced labor issues or human rights in the supply chain. And one of the people on the conservative side said something to the effect of, "Well, at the end of the day, we don't want to have to pay a lot more money for these products." And my kind of instinctual response was, I know how much products cost. I know how much an iPhone costs, and I know how much of the portion of the costs are, labor costs versus intellectual property versus materials and all these other things. I would imagine that it would not cost consumers in, say, developing markets or developed markets rather, very much in terms of price at whatever product, just to ensure that workers are treated fairly.
Yeah, as one example, that's a very good point. As one example of that, if you take an average chocolate bar and you increase the price by 6 cents, you could
Yeah,
double the price paid to the farmer.
yeah,
So,
exactly.
I mean, could the consumer absorb that 6 cents on the chocolate bar? I'm going to go with yes.
Yeah.
And then it almost really raises the question, why has this not happened? So this question about, well, do people want to pay a lot more? Well, if it really does cost a lot more, which to your point, Patrick, I don't think it does in most cases, but if it really does cost a lot more, maybe that's the actual cost of this product. You can't
Yeah,
just off your costs
yeah.
off on global South countries that can't afford to resist that. And so then they sort of absorb all of these costs, these corporate externalities, right? Put in economic terms. I think that the idea that companies can have these massive externalities, whether that is pollution or occupational health and safety violations that result in worker injuries and people who are sort of worked to the bone until when they're in their 40s, they're no longer able to work anymore. That has an impact on the local economy. It has an impact on the local community, and it shouldn't just be externalized onto people who can't really absorb those risks. It should be internalized to the company that has a huge profit margin and absolutely is able to absorb those risks. So I think that with the cost question, either the price has to go up for the consumer or the company can absorb it and it's not that much. And that's just kind of the answer. There's not really any other
And
answer.
another issue with cost is, if it's 20, 30% higher than it otherwise would be, oftentimes that's because there might be only one company that's doing it, but the vast majority of the market isn't doing it, which helps lead to the kind of the approach in the EU space where it's human rights due diligence, because at least it's kind of company wide, it's market wide, and creates changes in the market, which is really what you want. And it's tricky. I speak sometimes to antitrust lawyers, and when I talk about different industry initiatives around these, they get spooked out right away, because when they hear industry initiative and collective action relating to price or relating to the price that you pay for certain products, they worry about enforcement of antitrust laws. And companies, or rather consumers, probably don't think about that.
I think the best example of what you just said is the International Cocoa Initiative and the World Cocoa Foundation. I mean, the Federation Foundation. These institutions, and really less so the ICI, but I think that these institutions, they bring all of the companies together to align on sustainability, but it's really, they've aligned on sustainability noise. So at the beginning of all of their reports, they have like an antitrust disclosure statement saying this isn't really an antitrust violation. I think if they were actually coming together to do something that was economically disadvantageous to the company, it would not be an antitrust violation, because they're not doing it for the profit of their company or the profit of the industry. They're doing it something that is really for legal compliance, sustainability, whatever. It's just not an antitrust violation. So I think that if they're doing something good, then they don't run an antitrust risk in the same way if they're doing it just to mislead consumers in order to protect themselves from regulation and protect their prices and their profit margins, et cetera. Then I think they are more in a risk zone. So I think that kind of is like if they think about it that way, there's a certain accountability in it, that if they want to avoid antitrust, but they want to coordinate on sustainability, just do it really well in a way that isn't just improving your bottom line, but is actually improving conditions for workers and the communities you impact.
Yeah, I couldn't. Yeah, well, you never know these days. I was going to say, I wouldn't imagine an FTC prosecutor bringing a case like that, but then you could see a different political regime. You see the backlash you have to ESG laws. Who knows what could come? So you've been really generous with your time, which isn't surprising because you're really generous with a lot of the different work that you're doing, Ms. Ryerson. I wonder, are there any kind of final thoughts that you'd like to leave us with, or any kind of thoughts you have for the future? We didn't get into the amicus brief that your organization did in the Rata case, but I think we've talked about this on other areas of the podcast. Of course, it's important because it's a Ninth Circuit case. You could talk about where you see the enforcement of the TVPRA, or maybe something broader.
Yeah, I guess maybe as a couple of final thoughts, for folks who are law students or early career lawyers, a lot rides on you. If you are potentially going to take a big law job, or you're even working at a smaller firm, but you're doing any kind of corporate law, the way that you advise your clients is really going to be what is going to determine outcomes for millions of people around the world impacted by corporate supply chains. And so there's, I think there's in law schools, there's a lot of questions like, are you going to go big law? Are you going to go nonprofit? The reality is there's not that many nonprofit jobs in this space. So if you want to be on the advocate human rights side, you're a little limited. The corridor is very narrow. Whereas if you just want like a job, the vast majority of you are going to wind up in corporate law in some way, because that's where the money is. And so that's where the jobs are. So I think no shame if you go there. But hold on to your values. Just because you went to law school and had these great values, and then you came out in the real world and you said, well, now this is the work, this is the job I have, this is what I'm going to do. That's what most people do. What if you tried to hold on to those values in those spaces and really forge a different path and push for something better? And if you're in an environment in which it's not possible to do that, where you try to hold on to your values, then maybe that's not an environment you should stay in. And I think it's worth saying goodbye to that job if you can't do it. So I guess that's one point I'd say. Otherwise, just as a general sort of thought on what's the future of this field, where are we going, what's working and not working? Right now, I think the best game in town in the United States in federal law is probably the TVPRA, because it has extraterritorial application. There's some things about the language that make it a little bit easier. We have really lost the Alien Tort Statute. The torture statute, which also applies to extrajudicial executions, was limited in 2012, so it can't be applied to corporations, legal entities. It's only individuals or natural persons. So insofar as it's forced labor, we do have one good statute that can really be used. And otherwise, I think it's really important to think about what other laws are out there, even if they are not human rights or environmental oriented on their face, and just get really creative, because it takes all of us to innovate, and we all need to be innovating and trying to solve these problems together. So if folks want to join Cal in doing that, I would encourage you to reach out to us about fellowships, internships. You can become a donor. We take pro bono support on a lot of our projects, legal research, et cetera. But there's a lot of great organizations out there doing this work. So I hope that everyone can get involved in whatever way they can to move this work forward.
Thanks so much. One of the reasons for that we have this show is to allow maybe the younger associates, a place that reiterates that your values are worthwhile. And even if you're getting pushback maybe from more senior associates or partners who might be more conservative, or grew up in a time where ESG or responsible business conduct wasn't as in vogue or anything like that, that people who are from our newer generation, our values do make sense, and they are coherent and useful and effective, and so that's why we have.
Amen.
Okay. Well, thank you very much. And I think that's all for us. Thanks for stopping by.
Thanks, Patrick. Great being here.